So, very good morning, YouTube family. Hope all of you are doing fine. So, we'll begin in a minute or two. Kindly note, this class is helpful for all NTA UGC net aspirants. The paper is law. And today we'll be discussing about interpretation of law. That is mainly statutes or legislations. So, I'm your educator Cyril Jacob. Kindly follow me on Unacademy so you will get access to all my content, provided you also subscribe using my referral code Cyril Thomas Jacob. That's my referral code. You get a 10% off using my referral code. So CYRILTHOMASJACOB. These will help you. And there are many benefits of Plus. I'll be getting into a minute. Meanwhile, a brief introduction about myself. Myself, Cyril Jacob. I hold a bachelor's in law from Kerala University. I pursued my master's in commercial law from Bristol Law School, England. I hold a diploma in cyber law from Asian School of Cyber Laws and GLC, Mumbai. Apart from all this, I'm also a MBA graduate from Bangalore University. So kindly note, these are my qualifications. I'm also an independent practicing lawyer, apart from being an internationally published author. My work has been published in international journals, right? So we'll begin in a minute. Dear friends, please note, if you have any doubts, I'm connected on my phone, so you can go ahead and post it in the comment box and I will clear it for you right away, since this is a live streaming session. So the benefits of Plus. First one is you'll get the complete course on law. Right now I'm covering all the 10 units and I just started this month, this week in fact. And you'll be having access to all top educators content, as well as, since I'm covering almost all the units, in fact all the units I would say, I will be handling previous year's question papers. You also will have access to unlimited content, including quiz, that is weekly. It's a 20-minute quiz, and mega quiz is at the end of the course, that is per month. At every fourth session you have a doubt clearing session. Please note, my classes are 90 minutes, Monday to Friday at 5 p.m. So please subscribe to the 6-month plan, because NTA Net is a continuous evolution process and nothing happens overnight. So you need months of preparation. I highly recommend that you take the 6-month plan and you watch the content, and you'll be able to download the PDFs anytime, anywhere. You can view the recordings of the videos also on the app. So join Unacademy Plus right away. Don't forget to use my referral code Cyril Thomas Jacob and get a 10% discount on the subscription fee. Okay. So these are the benefits. My upcoming classes will include on constitutional law and family law, apart from, of course, intellectual property rights, information technology laws, Consumer Protection Act. A lot of things have been lined up. Right now, I'm conducting presently classes on jurisprudence, unit number 1 for your law paper. Kindly note my classes are in English only, and the notes also will be given in English. So let us move on to an introduction of interpreting statutes. Today we are having an important discussion on interpreting statutes. Kindly note, the tendency in the modern times is towards a process by which the whole corpus juris. The term corpus juris means the body of law. It's a Latin term, corpus juris, is reduced to the form of enacted law. What is enacted law? They are known as acts or statutes. So today's modern era, you will find that as the cases continue to grow in the courts, it is very important to interpret a codifying statute. That is, the main role of the judiciary is to interpret the law and to, apart from upholding the law. So in order to understand the intent of a legislation, in order to understand the proper necessity of a legislation, one has to interpret it in the most systematic manner. And judges in top courts do it. That's their main function. So what is a statute? A statute is a will of the legislature. It is an intention. It is the will of the legislature. Legislature means the parliament or the state legislative assembly, state legislatures. So a statute is a will of the legislature and it gives expression to its intention. These two words right here, it's a will and intention, should be taken into account. In case the language is plain, that is, it is simple and admits only a single meaning, the question of interpretation rarely will arise. Suppose a particular legislation, say we take the Indian Contract Act 1872. If the language in it is very simple, then there is no need for interpretation. However, something that is interpreted the most is the supreme law of the land, that is the Indian Constitution. It has gone thousands of interpretations in the courts of law. But when the question of interpretation hardly arises, then in such cases, whatever is enacted has to be enforced. However harsh or absurd or vague it may sound. But the duty of the courts or the judiciary is to always uphold the law and to ensure that the fundamental rights of the citizens are not compromised. Moving on, there is a saying that manifest absurdity of futility. Futile means in vain. Absurd means something that is not making that much sense, or palpable injustice. So if there is injustice or absurdity or futility, or if there is any inconvenience caused or any mistake, it must be avoided at all costs. This is a proverb. So absurdity, futility, injustice, inconvenience or anomaly. What is an anomaly? It is a wrongdoing, must be, or a fault, must be avoided while interpreting a legislation. It is not necessary that the words used by the legislature while formulating a statute will always be simple. It can have a complex dimension. However, the manner in which it is interpreted should be standing out. Hope it's clear. Any doubts, dear friends? Okay, let's move on. I would like to move on to a famous American case. It's called the Lincoln College case. It's a 15th century case. In this famous case, it has been held that the good expositor of an act, that is, the person who is able to interpret the legislation or the enactment in a good manner, should make construction on all the parts together. That is, a person who is to interpret the law should take the law as a whole and not divide it and take it in one part by itself. This was held in the case of Lincoln College. It is a 15th century case, and today we are living in the 21st century, and this case still stands true till date. The process by which one tries to ascertain, that means determine or understand the meaning of the legislature through the wording of the enactment, is technically called interpretation. So this is the definition of interpretation. So interpretation is basically a process by which one person tries to determine or understand the wordings of the enactment, the meaning of the enactment, the definitions. That is why you have various provisions. You take any legislations, you will have a preamble, you will have definitions, you will have meanings, you will have certain small commentaries. So interpretation can be of two kinds. The first one is the literal interpretation. Second one, there is a rational, or there is a logic involved. Literal interpretation and logical interpretation. Dear friends, I encourage you to make notes of the slides. So please make sure you are able to jot down the points that I am providing. So what is literal interpretation? It is also known as grammatical interpretation, as it considers exclusively the verbal expression of law. The verbal expression of law. Okay, the wordings are very important. However, a literal interpretation does not go beyond, I repeat, it doesn't go beyond the literal meaning of the word or litera legis. Litera legis is a Latin term that means literal legis, literal interpretation. So according to the literal interpretation theory, the words of a statute are to be read in the ordinary sense, that is in the layman sense, in the common sense. So the primary, that is the first and foremost rule of construction or interpretation, is that it is assumed, there is an assumption. There is an assumption. What is the assumption? That the words and phrases of technical legislations are used in that technical sense. So the technicalities should be considered. It should be observed. And the second factor is that the phrases and sentences are to be construed as per the rule of grammar. So a grammarly context also should be looked into. Now there is a famous judge. His name was Lord Evershed. In fact, there is a firm called Eversheds. If you look into the database of the law firms of the world, Evershed is a leading law firm. But there is a judge called Lord Evershed. He goes on to state, and I quote, "The length and details of modern legislation have undoubtedly reinforce the claim of literal construction as the only safe rule. So what this basically means is that what this statement goes on to state, what goes on to highlight is that literal interpretation is followed till date, and it is a safe call for interpreting or construing what a legislation or a statute stands for, right? So definitely there will be lengthy or detailed legislations out there, but we need to consider the technicalities, we need to consider the grammarly context, we need to consider the meaning in a literal fashion. That is what even Lord Evershed highlighted in his statement. Is it clear? Any doubts? Please go ahead and ask in the comment box. Now there are exceptions to the literal interpretation. And the first one is where the law is logically defective. That is, there is a defect in the law, there is a mistake. For instance, there is a failure to express a single or definite or logical coherent complete idea. Then logical defects by which the literal edges may be affected include ambiguity. What is ambiguity? It means uncertain or vague. Unclear. So a word used in a statute, instead of meaning one thing, if it has two or more different things, it can be said to be a little bit unclear or vague. The right word is, in the legal context, is ambiguity. So the use of the word property in a statute may mean movable or immovable property. In such a case, it is the right and duty of the court to go behind the lines, behind the letter, to ascertain the true intention of the legislature. For example, you take intellectual property rights. It is intangible rights. You take Motor Vehicles Act, there you have motor vehicles involved. What are motor vehicles? They are movable property. Then you have the Transfer of Property Act. It involves immovable property. So many things are there. And there may be instances where the meaning of a word in a legislation or a statute or an enactment may mean more than two different things. But it is the right and the duty of the court to interpret it by reading between the lines. Reading between the lines means to ascertain the true intention of what the legislature decides to convey. Now, inconsistency. This is also a logical defect. Literal edges consisting of self-evident error. For example, if one section of an enactment or a statute contains one provision granting a right in favor of a person and which is negative by another provision in the same statute, that is known as inconsistency. It's not constant. One section says something and another section is providing another term. That is inconsistent. Then incompleteness. That is another problem. So in case there are two alternatives possible, the law may make provision for one of them to remain silent over the other. Okay, and such omission the court may lawfully supply by way of logical interpretation. So in case if there is a logical defect, that is, if the legislation or statute is ambiguous, if the statute is little bit vague or inconsistent or even incomplete, it is the duty of the court to legally, to lawfully supply the logical, that is the proper rational interpretation of the particular or respective enactment or statute. These are the exceptions to the literal legis rule. Is it clear difference? Now this is the first exception. Moving on to the second exception. The second exception is that in which the text leads to a result so unreasonable, that is, there is a problem of unreasonableness. So there is a self-evident error that the legislature could not have meant what it said. Let me take an example over here. So if there is any clerical error in the text of the enactment, such as a provision error or a reference error by a wrong number or the omission of a negative aspect in some passage of the enactment in which it is clearly required, then that is a unreasonable self-evident error, and this is a second exception to the rule of literal interpretation. So it is a duty of the courts over here to make the appropriate or the most apt interpretation using logic as well as being reasonable when interpreting the enactments. Hope it's clear. We looked into the literal interpretation. Now, next aspect is the logical interpretation. So, logical interpretation has an alternative terminology. It's called sententia legis. Okay, sententia legis. This is once again, a Latin terminology. Dear friends, please highlight this in your notebooks, in your notes, so that you will not miss out. All these are important from your net point of view. The logical interpretation, it is applicable in that case where there is a deviation, departs from the letter of law. So there is a deviation from the law. If a situation arises where there is a deviation of the law and then seeks elsewhere for some other and most satisfactory evidence of the intention of the legislature. So the intention of the legislature is very important. And if the intention of the legislature is deviated from, if any letter of law deviates from the intention of the legislature, then it should be, logical interpretation rule should be implemented. I will explain it to clarify. So this sort of interpretation or this rule of logical interpretation gives effect to the intention, to the will of the legislature. Not by just wordings, not by wordings alone, but also from other sources. What are these other sources? Historical sources. Okay, for example, history of law. Then the mischief that was sought to be remedied by the statute, that is another source. Then discussions in the legislature, that is discussions in the concerned legislature. It can be a parliament or the state legislative assemblies. So legislations are made at two levels. In India, if you take, they are at the central level, which is the parliament, and at the state level, which is the state legislative assemblies. So this effect to the intention comes from not only wordings but also from other sources. And logical interpretation is referred to by some jurists, some international jurists call logical interpretation as equitable interpretation. Kindly note, equitable interpretation. Dear friends, all these are really important, so please take down. For the administration of justice, the judge has to comprehend, that is, he has to understand the real meaning of the statute, and he has to give natural reasoning, provided that logical interpretation is more suited for it than literal interpretation. So there has to be a rationale behind giving an interpretation. That is what the logical interpretation suggests for. So there is a huge difference between logical and literal edges, that is sentential edges and literal edges differs. One tries to ascertain the meaning, the literal meaning of the words used in the statute, and the other tries to look for the rationale or the intention or logical aspect in the statutes. It considers the wording as well as the other sources from which you can derive the meaning of the statute or legislation. Any doubts, friends? Okay, I believe it's clear. So let's move on. Now the mischief rule. This rule is derived from Hayden's case. Hayden's case is another international case where the court laid down for rules to be followed in interpretation of statutes. And the court held that for the sure and true intention of all statutes, for the proper interpretation of statutes in general, they be penal or beneficial, that is, or restrictive or enlarging of the common law. So four things are to be considered. The first one is, what was the common law before the making of the act? So you trace common law. And what is the mischief that was committed and the defect for which common law did not provide? So you're looking at the aspect of the cause of action. Third one, you're looking for remedial measures that the parliament, that is the legislature, had resolved and appointed to cure the disease. So what is the remedial measures that were suggested? And the true reason for the remedy. So these four things were to be considered for proper interpretation of law. This was laid down by the court in Hayden's case. It is an international case law. Once again, I'll repeat it for you. What is the common law before the making of the act? What is the mischief? That is, what is the defect? What is the wrongdoing for which the common law did not provide for solution? Third one, what is the remedial measures suggested by the parliament and appointed to cure the problem? And fourth one, what is the true reason for bringing up that remedy? This is known as the mischief rule because it considers the mischief or the defect and the remedial measures it suggested. Right? Now there is another rule, golden rule. This is a slight modification or amendment. It amends or alters the literal legis rule. That is the literal interpretation. This rule is a modification of the literal legis rule, and according to this, the literal sense of the word, the literal meaning should be adhered to unless it would lead to absurdity, where the literal meaning will be modified. So if there is any absurdity, the literal meaning can be modified. Please note, only when the words are absolutely incapable of a construction or interpretation, which will accord with the apparent intention of the provision. Only if the intention of the provision given by the legislature, if it is not clear, then the courts will go beyond the words of the statute. Only if it is impossible, that is absolutely incapable means it's impossible for a interpretation, then the courts will look forward to the interpreting the statute. So the golden rule, the purpose of it is it's done to avoid an unreasonable result. And most people consider courts as reasonable. Courts are reasonable interpreters of the law. Okay. So the words of the enactment will prevail if it is reasonable interpretation. Otherwise, if there is an unreasonable result, then the courts will go beyond the words of the statute and try to interpret it. So this is the golden rule of interpretation, right? The golden rule of interpretation. Kindly keep both the rules in mind. One is the mischief rule, second is the golden rule of interpretation. Look at the strategies. Okay, if you look at the introductory slide for strategies for learning the interpretations, the following principles are looked into. Okay, please note down the following principles are used by courts while interpreting statutes. Okay, the first one is harmonious construction. Second one is statute should be read as a whole. The whole act must be looked into or observed. Then there is another Latin proverb that ut res magis valeat cum periet. Then nocitior a socis, est judem generis. This is a very important principle of general aspect. All these Latin terms should be studied. Then expressio unius est exclusio ulterius. Then general is specialibus non derogant. Then contemporanea expositio. Then in Burnham Partum. Then redendo singulis and in pari materia. Please pardon my pronunciations if it's wrong. I'm sure it sounds a bit funny, but please manage with me. I'm not a Latin speaking individual, so I'm sure you'll be able to understand. But these are the Latin terms which contain principles. So I would say it's Latin principles. Terminologies, important terminologies. So harmonious construction. If you look at the harmonious construction, when there are two provisions in the same statutes that are contradictory to each other, when there is a contradiction in the same legislation, then the court will try to understand the provisions in such a manner in order to give both a peaceful consistency meaning. And this is known as the canon of harmonious construction. This is the principle. So when there are two alternative provisions in the statutes, one which should make the provisions inoperative and another which may give effect. So operative and inoperative provisions, if it exists in a statute, it is the duty of the courts to adopt the latter, that is, which gives the effect to both the provisions. So a construction which harmonizes the object, that is the purpose of the statute, must be adopted. This is also called the canon of the harmonious construction. It's an important principle. Any doubts, dear friends? Please go ahead and ask. So when you say statute as a whole, while considering the provisions in a statute, all the parts, I repeat, all the parts of the legislation should be taken together and read as a whole in order to, what is the purpose of this? To find out the intention of the legislature. The intent should be analyzed. According to this principle, a statute is to be interpreted ex viceribus actus. That is, a provision in a statute cannot be interpreted in isolation. You cannot isolate a provision of law, as it will cause undesirable results. The consequence will be negative. Not intended by the legislature. So there is a famous Indian case law. In the case of Popatlal Shah versus State of Madras, it is an All India Reporter case. It is an old case. Please note down. This is reported in the All India Reporter in the year 1953 by the Supreme Court at page 274. So in this, the Supreme Court observed that it is a settled rule of construction that in order to ascertain the legislative intent, all the constituent parts, that is, all the wordings of a statute or all the passages are to be taken together. They should not be isolated, but each word, each phrase or sentence is to be considered by giving importance to the general objective or to the general purpose of the particular enactment or statute. So the Supreme Court made a very clear decision in the case of Popatlal Shah versus State of Madras that the law should be read considering all the parts of the enactment and not in isolation. So statute should be read as a whole. That particular principle of ex viceribus actus, provision is in a statute, cannot be isolated. Rather, it will lead to undesirable results. So for that, it should be read, the statute should be read as a whole. Hope it's clear. Utres magis valeat cum periat. So the meaning of this maxim is that the thing may have effect rather than be destroyed. So it's better to make the statute operative rather than destroy it. So based on this principle, if two interpretations are open, the alternative has to be chosen. Which alternative? The alternative that promotes the purpose of the act. And the other alternative should be rejected. I repeat, the other alternative, former one, should be rejected, which will introduce any uncertainty regarding the smooth functioning of the particular enactment or legislation. So again, this calls for a harmonious aspect to it. And the Supreme Court, in the case of Commissioner of Sales Tax versus Mangal Sen, this is another Indian case law, please note down. It is reported in the All India Report in 1975 by the Supreme Court at page 1106 or 1106. And the Supreme Court in this case observed that a statute is supposed to be an authentic storage of the legislative intent or will. That is, authentic repository. The word authentic repository is highlighted here. It means the intention of the legislative will should be able to be authentic, and the function of the court is to interpret the statute based on the intention of them that made it, that is the members of legislature. Okay, so under this principle in the maxim, you should understand that in interpreting a legislation, the duty of the court is not to defeat, but rather to make it effect the intent of the legislature. It should come into effect. That is, the court should effectuate the intention of the legislature, the will of the legislature. That should be clear. Right? Another principle, nocitur a socis. This maxim means the meaning of a doubtful word. If there is a doubt in the meaning, it may be determined with respect to, with reference to the meanings of words associated with it. So you should read as a whole and not in isolation. So this associated words should also be, that is, words that follow. Following terms should be observed. This rule was evolved by Lord Bacon, okay, and it applies where the word isolated from the context yields no sensible meaning, but when associated with other expressions gives a sensible meaning. So let me give a situation. Suppose you're reading a novel, you're reading a book, one of your favorite authors, say Harry Potter. You're not able to understand certain complex terms by reading one particular word. But if you read a full paragraph or the full sentence, you will try to associate the meaning of the word and it will make sense to you. Sometimes individual terms will not make sense to you because they are complex in nature. However, how do you interpret that particular paragraph or how do you interpret that particular passage? You should be reading the associated words along with it. Okay, that's the maxim, nocitur a socis. It means that the meaning of a doubtful word may be determined or ascertained, provided you give consideration to the meaning of the words associated with it, with reference to the meaning of the words associated with it. Now, this is a very important principle. Many of you may have heard about it. It's called ejusdem generis. So this literally means of the same kind or species. There is a general aspect here. When you see the word generis, ejusdem, just remember that there are general words. So according to this principle, if at all there are general words following particular or specific words, the general words must be confined to things of the same kind as specified. Okay, this means of the same kind or species that is specified. So there are certain conditions in order to apply this rule. They are listed below. The first one, point A, the statutes must contain an enumeration by specified word. That is, it should list or enumerate the specified words. And the enumerated terms must constitute a specific class by itself. And that class must not be exhausted. It should not be ending. It should not face an end. Rather, the general term should follow the enumeration. There should be following of particular words, particular or specific words. And the class must contain several items of which some at least are mentioned. This is a condition for applying the principle of ejusdem genesis. And point F, there should be no clear proof that the general term had no broad meaning. So there should not be a situation where there arises no proof that the general term had no wider perspective. Any doubts, dear friends? Kindly ask. Now, expressio unius est exclusio ulterius. Now, this is another Latin term. This maxim means that express mention of one particular thing. So if there is an expression of one thing that it implies, the express meaning will give to rise to an implied meaning, the exclusion of another. That is, if one or more things of a particular class, that is a specific class, they are expressly mentioned in a statute or enactment, what will it convey? It will mean that other things belonging to the same class are excluded from the domain of the enactment. It is a little bit confusing, I'm sure. So I will go on to a definition of or statement of Maxwell, who is a famous jurist, and he goes on to explain this particular maxim or Latin term by saying that where there are two expressions, and if they have been used in a statute, if they have been used in an enactment, of which one of which generally includes the other, and the more general excludes the less general. This will be the situation. The more general excludes the lesser general. So there is an exclusion aspect that is highlighted here. So it means that other things belonging to the same class are excluded from the domain of enactment. Okay. Moving on to the next maxim. Generalia specialibus non derogant. In this case, the legislature passes a special statute dealing with a particular subject. Okay, there is a precise enactment regarding a particular subject. Later, the same legislature makes a general enactment which should include the subject of the special act also. So there is an inclusion here. So if a question arises to the effect that the provisions of the special statute would become inoperative, that is, if at all the provisions of the special act becomes inoperative, what is the rule to be followed? The rule that will be adopted is that the provisions of the general act will not, I repeat, shall not override the special statute. The special statute should also be given its due, but provided this means that general statute will not, in the absence of clear words, be construed. Construed means interpreted as taking away the provision of the same statute. So the intention or the object or the will of the legislature should not be compromised. That is what this particular term means. Generalia specialibus non derogant. That is the rule to be adopted in a case where, if at all a question arises regarding the effect of provisions of special statute, the rule to be adopted is that the provisions of the General Act will not override the particular special provisions, special statute. Hope it's clear. Now the next term, contemporaneo exposito. So this maxim means that a contemporaneous exposition is the best and most powerful while interpreting statutes. So this is considered as a much is followed in many countries, including India, and this principle is applied in the interpretation of ancient statutes. Ancient statute means historical legislations. It will not be much of use for the interpretation of statutes which are comparatively modern. So, okay, this problem, it can be used in countries like America, not India, sorry. It's followed in many nations, but Britain follows it, America follows it, but regarding India, it doesn't follow it. Okay, so earlier I had mentioned India follows it. No, the thing is that India has modern legislations. Enactment started from the year 1836 only. So this rule is not much used in case of Indian legislation. However, that being said, some tend to look at historical statutes too. Okay, in the case of senior electric inspector, this is an Indian case law. Please note down. In the case of senior electric inspector versus Lakshmi Narayan, reported in the All India Reporter 1962 by the Supreme Court, precisely at page 159, the Supreme Court refused to apply the principle of contemporaneo exposito in order to interpret the telegraph line in the Indian Telegraph Act of 1885. So there has been a situation in the year 1962 when the Supreme Court refused to accommodate the principle of contemporaneo exposito because it said that or it is too way beyond its consideration. They are too ancient. Now, law is something that should be constantly evolving, and Supreme Court considers that. You cannot look at ancient laws and try to bring it in today's time. Okay, so the world has evolved, and the law is also an evolving aspect. Any doubts? Please put in the comment box so I can clear it. Yes. Now, in Burnham Partum. The expression in Burnham Partum literally means in accordance with the law or as per the law. So it's a general rule in the construction of statutes that the expressions or words in the statute should be given a lawful sense. Okay, a legality should be given. Lawful means legitimate and recognized by the law. Where an enactment or an act refers to a thing to be done, it's to be taken as referring to be lawfully done in accordance with the law. That's the literal meaning of in bonum partum. This is an important principle of interpretation of the law. Now moving on, redendo singula singulis. So according to this principles, okay, in this maxim, in order for correct interpretation of statutes, the arrangements of words must also be taken into account. The placement of words, this means the placement of words must be clear and unambiguous. There is no necessity to look into an interpretation when the placement of words is clear and unambiguous. But however, if the placement is not clear and ambiguous, then there is a necessity to look into the interpretation. So there is a famous judge, Lord Crawford. He points out that if the enactments or statutes are read without breaks and stops, they would not be clear. There should be proper pausing. That's what he means. The words belonging to any particular branch of a sentence must be collected from the context. There should be a collection. The context should be studied and read accordingly to the principle of redendo singular singulis. That is, correct interpretation of statutes, the arrangement of words should be taken into account. For instance, in the expression, okay, this is an example. If anyone shall draw or load any sword or gun. So what does the statement mean? The word draw means is applied to sword. You cannot draw a gun. You can load a gun. As it is impossible to load a sword and draw a gun. Okay, you can load a gun and draw a sword. So the interpretation, the proper arrangement of words, the placements of words should be considered. That is what this principle of redendo singular singulis calls for. Now, in the case of K.V. Kamath versus Rangappa and Company, it was held that each expression in a statute is to be referred to its appropriate objects or the perspectives. So, if you look at Article 304 of the Indian Constitution, there is a provision which reads, provided that no bill or amendment for the purpose of Clause B shall be introduced or moved in the legislature of a state without the previous sanction of the President. So if you're looking at this particular statement of Article 304, the Supreme Court held that the word introduce refers to bill and the word moved to amendment. These two words. So the importance of words should be accordingly placed. Now in pari materia, this maxim literally means in an analogous position. So according to Maxwell, statutes are said to be in pari materia. That is a Latin term. That is when they deal with the same person or thing or class. So they should be substantially identical. The concept of identicality comes into play. So the same words or phrases used in acts dealing with the same subject matter should be taken into context, often by the same meaning. However, the same phrase may have different meanings in different statutes. So there can be a distinction also. But in pari materia means they deal with the same person or thing or class, they should be substantially identical. The case law to explain this particular principle or maxim is that in J.K. Steel Limited versus Union of India, reported in the All India Report in 1970 by the Supreme Court at page 1173, the Supreme Court observed that while holding that the Excise and Salt Act and Tariff Act were in pari materia, that is, they should be according to the same person or class, the court observed that the above two acts form one code, that is, they formed one particular statute, and must therefore be taken together as one system, and regarding the interpreting, it should be interpreted as one and enforced each other based on the principle at hand. That is, which is the principle at hand in pari materia. Okay. Now there are various internal aids to interpretation, internal tools, okay, to interpretation. One is preamble, next is title, third one is headings, fourth one is marginal notes, fifth one is definition clause, sixth one is provisos, seventh one is exceptions and saving clause, eighth one is legal fictions, ninth one is explanations, 10th one is illustrations, 11th one is punctuation marks. These are the internal tools to interpretation. This should be carefully observed. Preamble, title, headings, marginal notes, definition clauses. I would say this highlights the meaning. Illustrations are examples. This goes on to say pauses are also important. Explanation, of course, to understand, and legal fictions. Exceptions, exclusions, and saving clauses should be also observed. Sections are ultimately important, but the preamble should be also looked into. Now, the external aids to interpretation include dictionaries, textbooks, legislative history, administrative conveyancing and commercial practice, committee reports, that is official committee reports, and foreign decisions. So international cases also play a big role for interpreting the statutes. These are external tools. So now we studied the strategies as well as the interpretation of statutes. Okay, and dear friends, please make sure you use my referral code and subscribe. Follow me on Unacademy. My name is Cyril Jacob. Please use my referral codes to get a 10% discount. Okay, and the benefits of Plus, once again I'll highlight. You get the complete course on law. It covers all the 10 units. Upcoming classes include constitutional law and family law. Moreover, all the remaining topics will be covered. My sessions are 1.5 hours. You have a few minutes break in between, but definitely please stay tuned. The YouTube sessions and all doesn't cover the entire syllabus, so you will have to also subscribe using my referral code and get a 10% discount. I suggest you subscribe for the 6-month plan, and don't forget to join Unacademy Plus family. So today we highlighted introduction. We dealt with what interpretation is, right? Lincoln College case, literal interpretation, logical interpretation. We highlighted the 2 rules of interpretation which are very important, Mischief Rule and Golden Rule, and we also considered various strategies. Thank you for joining me, dear friends. It has been a pleasure holding a session on YouTube. Hope you have enjoyed the lessons. Right now, wishing you all a good weekend. Take care. God bless. Cyril Jacob signing off.